Hello, my name is Maria Horat, and I'm a real estate broker in Northern California. And today I have a part one of a series about California real estate disclosures and why you should absolutely disclose what you know when you sell a home, how to avoid headaches and lawsuits that come from not doing it, and the fact that California has some of the strictest disclosure laws in the nation when it comes to real estate. And in this video, we'll walk through the three core disclosure documents you will see in almost every residential sale. There's quite a few more, but the main three are the transfer disclosure statement, the seller property questionnaire, and the agent visual inspection. I will also explain what material facts are and why a licensed agent helps protect you. We'll look at the three real estate court cases that can show you what can go wrong when material facts are not properly disclosed. Are you or someone you love ready to downsize or thinking about selling a home but overwhelmed by years of accumulated belongings? My name is Maria Horat, and I am a real estate broker and estate sale liquidator, and my team makes the process simple and stress-free. We'll help you turn treasures into cash with professional estate sales. Prepare your home for market fast and for top value. You don't need to juggle multiple companies. We are your one-stop solution to real estate and estate sale liquidation services. Call us today and let's make your downsizing and selling process smooth, profitable, and stress-free. You might ask yourself, why does this matter, whether I disclose one thing or another? If I'm selling the property as is, why does it matter whether I disclose things or I don't? So failing to disclose known problems can lead to claims for fraud, misrepresentation, breach of contract, and expensive litigation or rescission of the real estate sale. California law requires sellers to answer honestly on the statutory transfer disclosure statement and related forms, and agents have a legal duty to do a reasonable visual inspection and disclose what they know or should have reasonably find. Those duties are optional. An as-is sticker doesn't erase them. So the fact that you want to sell the home as is doesn't mean that you don't have a duty to disclose every material fact that you're aware of affecting the property. Let's talk about the transfer disclosure statement. So the transfer disclosure statement is a statutory form California sellers use to disclose known defects for 1 to 4 unit residential properties. He asks about structural problems, water intrusion, roof leaks, pests or wood-destroying organisms, plumbing, electrical, neighborhood nuisances, environmental hazards, and much more. The legal point is simple. Disclose what you actually know. And if you know about a defect, you must report it on the transfer disclosure statement. Even repair problems should be disclosed with an explanation of the repairs. Failure to deliver or failing to be truthful on the transfer disclosure statement is a core basis for buyer claims. One practical tip that I have for you is that before you sign a transfer disclosure statement, walk the property room by room and jot down anything you or your family members know about, such as leaks, previous flooding, disputes with neighbors, unpermitted work, even permitted work you can note on your transfer disclosure statement. Past termite treatments, septic work, how many times the septic has been pumped, if you have a septic system. If you don't know, say what you don't know. You're only required to disclose what you actually know, but don't guess or be evasive. Next, let's talk about the seller property questionnaire. This is often a companion to the transfer disclosure statement. It's a more detailed Q&A, and it covers things like permits, additions, boundary disputes, HOA matters, history of insurance claims, and more. The seller property questionnaire helps buyers and their inspectors decide what to investigate. And it becomes evidence later if a buyer alleges the seller misleads them. Answer the seller property questionnaire fully and attach explanations or receipts if needed. It's not a substitute for inspections, but it's a sworn account of what the seller knows. Let's talk about now about the agent visual inspection. The agent visual inspection is a form that is required by California law, it requires broker and licensees to perform a reasonably competent and diligent visual inspection of the property. This is why it's so important that you have a professional, knowledgeable, and experienced real estate agent or broker working on your side. And this agent is required to perform a reasonable, competent, and diligent visual inspection of the property and to disclose material facts they observe or discover in the agency relationship. In short, the agent can't close their eyes and sign the listing. Agents use forms like an agent visual inspection disclosure to record obvious defects and any information the seller gave them. If an agent sees a fresh water stain on a ceiling, active leaks, or obvious foundation movement, they must disclose that to the buyers. If the agent fails to do a reasonable inspection, both the agent and the seller can be exposed to liability. A practical tip for sellers that I have is to work with an agent who documents the inspection, asks questions, and keep written notes. That paperwork can reduce misunderstandings later. Now, let's talk about what material facts are. What are material facts? Material facts are pieces of information that will affect a reasonable buyer's decision about the property or its value. Some of these topics will be safety issues, structural defects, environmental hazards, criminal activity on the property in some circumstances, major repairs, undisclosed additions, etc. So why hiring a professional reduces a risk? You'll hear me say this often: hire a good real estate professional. A licensed agent knows the forms, knows the common disclosure traps, and most importantly, will document the inspections and the seller statements. Agents can help with phrasing disclosures, collecting receipts and permits, ordering the required reports such as a natural hazard disclosures, making sure everything gets into escrow. That doesn't mean it will make you bulletproof, but it reduces your exposure to litigation because you have followed standard procedures and created a paper trail. Agents are also required to advise sellers honestly and to avoid misrepresentations. Now I just want to talk about some of the litigation cases that had to do with real estate and failure of disclosing all these material facts. So there are some examples. There was a case, Spruill versus Jorovic. It had to do with water intrusion. Unfortunately, the seller failed to report these pre-existing water intrusion problems. And remember, a lot of times it's not out of ill intent to not disclose. A lot of times it's an oversight that the homeowner doesn't think a certain item needed to be disclosed, or perhaps forgot to disclose a certain thing, especially if it's an older home and there is a lot of things going on, or maybe the person hasn't lived in the property. And that's another thing. If you haven't lived in the property, you will have less knowledge of material facts going on. So you'll definitely want to disclose the fact that you haven't resided in the property, perhaps if it was a rental. And a lot of times it might help to order a home inspection or a pest inspection or a roof inspection prior to the home going on the market. So you have all those reports available for the buyer. They can go ahead and do their own inspection if they want, but at least you have something to provide to them, especially if you haven't lived on the property. So this particular case, Spruill versus Jorovic, the judgment awarded was $539,079. And it was an individual seller who was sued by the buyer for failure to disclose pre-existing water intrusion problems. Water intrusion is very common. A lot of times people have a leaky roof. Sometimes the water kind of seeps through in the basement or under doors. Sometimes this can go unnoticed for a long time, or a leaky toilet. Another case was Godfrey versus Stein Press, and this was an older case back in 1982 for non-disclosure and fraud. The amount awarded was $1,800 in compensatory damages for the property loss, plus $10,000 for each of the people who were on the suing side for emotional distress and punitive damages, $30,000 each. So who was sued? The individual seller. The jury found intentional concealment and fraud. Another one, these are more higher profile cases, the Rancho Palma Grande Homeowners Association, Ridley versus Shen. I'm sorry, Ridley and Shen versus HOA in Santa Clara. Another water intrusion, mold from abandoned well under the condo. The amount awarded was $1.8 million. And the judge awarded against the Homeowners Association for damages, including lost rents, repairs, and emotional distress. In this case, it was a larger amount. It was it was a higher profile case, a larger developer, condo mold settlements, some of these other examples. On this one in particular, it was $35 million. It was a luxury San Diego condo settlement in 2023, just a couple of years ago, and $22 million in Orange County developer mold settlement. The developer and builders were sued, and basically they had toxic mold claims against the builders or property managers for systemic construction defects and occupant injuries and property loss. So various smaller mold water damage settlements reported by plaintiff firms, mold, crawl space, moisture, amount reported on this particular one was $500,000. A lot of times the private settlements are not made public. This one in particular it was $500,000 settlement. It was a San Diego toxic mold landlord case reported on a plaintiff firm site. In this case, the landlord and the property managers were sued. So basically, we want to make sure that we are disclosing what we know, and we are as thorough as we possibly can to avoid this kind of headache. The last thing anyone can go through is to have to deal with this after you sell your home or you sell an investment property. So you want to disclose early and honestly. I like to tell my clients I like to have them fill out all these forms prior to the home going on the market. That way everything will be ready to go. You want to disclose early and don't wait until escrow and the last minute to get these forms filled out completely. You definitely, like I mentioned before, want to work with a qualified real estate professional who knows California disclosure law inside and out. And of course, keep documentation, all your permits, invoices, inspection reports, and attach them or reference them on your forms. So in closing, don't forget to check out the rest of this California disclosure series. These are very helpful to learn how to stay protected and keep your real estate transition smooth and compliant. And if you found this helpful, please subscribe and click the bell icon and drop a comment below with your disclosure questions. I might feature them on the next video. And remember, when in doubt, disclose it out. I am Maria Horat, a California real estate broker with Gold Country Properties, and thanks for watching, and I'll see you in the next one.